judge in residence, distinguished judge in residence, and he's a very distinguished judge, so that's a particular honor. And then this is the first of a series that I came up with the title Judgment Calls. Because if you think about that, well, judges have to make judgment calls, but judgment also calls, and judging for some people is something of a calling.
I saw that, and I wasn't sure if that meant the call of the court or divine.
Yeah, and I think we should leave that question open. But it's just, well, turn it on. I think that has happened.
You need volume.
It's green.
What's that?
So Judge Newman has written a book called Benched, and it's very entertaining. And you've had, oh gosh, how many years on the Second Circuit?
36.
And then you had 7 years on the district court in the District of Connecticut.
38, I cheated myself.
38, so 45 years as as an Article III judge. That's really quite extraordinary, and you're truly a gem. But why the book, and why the title, Benched?
Why the title?
Yeah, it seems like maybe you were instructed off the bench, like benching you.
Well, I guess it has 3 reasons. First, I'm an avid sports fan, so any sports allusion is compatible for me. Benched obviously refers to being on the bench, where I've been for a number of years. But it also had a secondary meaning, which the book mentioned. I think as among the 3 branches of government, the judiciary is a little bit on the sideline, despite some of the controversies that get the major attention from the Supreme Court. But certainly compared to the executive branch and the legislative branch, which have the power to go to war, the power to spend vast sums of money, I think compared to them, we are a little bit off on the side, certainly not unimportant, but I thought benched compared to them was an appropriate metaphor.
Right. But you have not been have you been writing the bench? Not really, because you've been such a central figure.
Well, that's where we do our work. We sit there.
Yeah, that is true. Okay, so I won't torture you any longer.
I don't mean I've been dispatched to the third string. No, yeah. I don't mean that. I don't mean that.
You haven't been.
Although my favorite item in the whole book is the photograph that I had taken in the training facility of the Baltimore Orioles. I asked them, could I do that? And they said, sure. And there's a photo, which I hope you paused over, where I'm actually sitting in the dugout of the Baltimore Orioles with my robe and my Boston Red Sox cap.
I didn't pause long enough over that.
It's a gem.
So why don't, as long as we're talking about metaphors, and why don't we maybe just to get it out of the way, sure. and you address it in the book. So the Chief Justice at his hearings said that judges were more like umpires than players, and that every subsequent person to come before the Senate for their confirmation hearing, Republican or Democratic president, has felt the need to make the same assertion in one way or another. And you take some issue with that. Why don't we just talk about that for a moment?
Oh, yes. All he does is call balls and strikes, he announced to the Senate. I don't like that metaphor at all, for 2 reasons. First place, I don't mind the idea that you're impartial like an umpire, and I think that's what he meant.
Yeah.
And of course, that's probably criterion number 1. But the reason it's misleading is, first of all, it suggests that there's only one rule. The umpire behind the plate has one rule. Is it a ball or is it a strike? One rule. We have more than one rule. We have hundreds of rules. You're all learning about them. And there are new ones come along from the Congress and the agencies all the time. So the idea that it's as simple as an umpire's one rule application is misleading. And secondly, although the strike zone is slightly variable depending on who the umpire is. It's a fairly clear rule. Whereas the rules we are asked to interpret, particularly if the case is significant, are anything but clear. That's why it's in court. If it was really clear, it probably wouldn't be a case. So it's misleading because there's more than one rule, and it's misleading because our rules are not as clear as the strike zone. Nonetheless, it's used all the time. The nominee finds it comforting to say it. The senators apparently find it comforting to hear it. And so I'm sure everyone from now on will continue to say, I just call balls and strikes.
Yeah, when I first heard it, I had the same reaction you did, which was he meant to really emphasize the neutrality.
Sure.
I'm not a player. In fact, a lot of people, you'll hear this a lot of the time. I've heard it from many people. I'd rather be a player than a coach. I'd rather be a player than an ump. They want to be in the ring, doing the principal activity, not on the sideline, so to speak. I thought, well, maybe you could say that a district judge making evidence rulings was calling balls and strikes, sort of in the hearsay area. But the truth is that most of the time when you're a district judge, as maybe you'll confirm for me, when you rule, it's often on 403 grounds, which is very discretionary. So you say, it's probably could be admissible. It's going to take more time than it's worth. And there's a kind of natural tendency to default to 403 because you know that the bad people that sit on the Court of Appeals are not likely to reverse you there. Whereas if you mistakenly, in the heat of the moment, made an erroneous call on a technical rule of evidence, you might find yourself getting overruled. So maybe an umpire could say, it's neither a ball nor a strike, it's 403. Like, it was a really good pitch, so I'm going to call it a strike, even though it really wasn't.
He meant to throw a strike.
He meant to throw a strike. So let's go back to the beginning and talk a little bit about how you came to the bench, because you had one kind of way there, which is, there was a lot of serendipity in it. It was not part of the plan, I don't think.
Not at all.
So would you talk about how you happened to end up as a U.S. district judge?
Well, I'll talk about both courts because the routes were quite different. The district court judgeship came about through one of the time-honored methods. I knew a senator. And as I've often said to students in other settings who ask, how do you become a judge? It's really very simple. If you look around this room and you identify the classmate most likely to become U.S. Senator, and just stay very close to that person for 20 years, that will improve your chances tremendously. So I knew a senator. I'd worked for a senator, Abraham Ribicoff, when he was governor, cabinet officer, and then U.S. Senator. And he sponsored me to become U.S. Attorney, and then the judgeship. Well, the judgeship was surprising in quite a way because the president was a Republican, Richard Nixon, and it's very unusual to appoint a district judge across party lines. It happens maybe 4 or 5% of the time, something like that over the years. So it was unusual, but it happened. But clearly, district court judgeships are senatorial patronage all over the country. Modified a bit by the fact that many senators have appointed lawyer committees, so-called merit selection, to recommend at least 3 or 4 people from whom the senator picks. But not all. Some senators don't do that, and they just pick somebody who they know very well. So that route was clearly senatorial patronage. Court of Appeals was entirely different. The Court of Appeals, I was appointed by President Carter in 1979. And he did something that no president had ever done before or since. When he became president, he appointed citizen committees in 11 circuits around the country. These were 13-member citizen committees, half lawyer, half non-lawyer. And the president committed himself by regulation that he would only name someone off of the list submitted to him by the committee. Typically, there were 5 names given for every vacancy. although in my case, since there were 2 vacancies at the same time, the Attorney General asked the committee for 8 names. But typically it was 5 names for 1 appointment. And if you weren't on the list, you were not in the game. That was absolutely clear, and he followed that scrupulously for 4 years. Ostensibly saying he wanted to do it to diversify the court, both from the standpoint of race and gender. Frankly, I never quite understood why he needed that technique, because if you want to diversify the courts by gender and race, all you got to do is name more women and minorities. But he thought if I populated these committees with women and minorities, they would develop slates of women and minorities. And indeed that happened, and the Carter appointees were a diversified group. Myself being a white male, I don't count, but aside from me, there were a number of women and minorities appointed. But that was the system. And the commission didn't just consider you, they interviewed you. And it was a vigorous interview. It was my interview with the commission, the Carter Commission, was far more vigorous than the Senate hearing after I'd been nominated. You were before the committee for a full hour. They asked very searching questions. First, a few softballs to just know who are you, whatever. You filled out an application, so they had background on you. But then they asked substantive questions. And I can remember getting one that said, the question was, Judge, what are your views on courts ordering affirmative action remedies? And I looked around the table, and on one side was a very conservative professor from the Columbia Graduate School, and at the far end was the very liberal black councilwoman from Bedford-Stuyvesant. And I said to myself, this answer is not going to please both of them. But as it happened, I had had some cases involving remedies. So I answered it. I said, here's what I have done. And I thought that while it has to be done with some care, affirmative action remedies are appropriate to remedy longstanding discrimination. And I think I was right. Mary Pinkett liked the answer, and the other lady, Diane Ravitch, did not.
In a sense, you were lucky because you had, or fortunate that you had a case you could point to, because you didn't have to, you didn't go outside of the public record. I'm wondering how that system, when you think about the way that question really searches for you to explain how you approach a legal problem. Now, a Supreme Court justice would say, well, of course, I can't give you any
It'll
window.
come before me, of course. They can't answer anything.
I can't answer anything.
That's right.
Yeah, unless you have a record.
Right.
So that's an interesting difference. Were you prepared by the department? You probably had no idea what the questions would be going into the... None.
No, they don't tell you. There was no shepherding by the department. Of course, these are what the Constitution lovingly calls the inferior courts. They don't pay much attention. The department does. They care who's there, but they don't care much about shepherding you through the process.
You know, you had such a varied and really wonderful political career before. You weren't a politician yourself, but working for Ribicoff, you were in D.C. when he was secretary of what was then called HEW, Health, Education, and Welfare, and you were his senior aide when he was a United States senator.
Right.
You worked for the Democratic Party in Connecticut, and you worked very closely on election matters. You had local, national, executive branch, and congressional experience, and it just seems like maybe there are people here that might think it's a little bit unorthodox. Maybe it was even at the time. Your other graduates of the Yale Law School probably didn't have that kind of experience, is my guess. But how did that help you?
Oh, I guess it surely helps. The legislative experience certainly helps to, it's not required, but it's helpful to see the legislative process in action. So that when statutes come along before a court that have vague language. I know I sit with colleagues and I will hear them say, how could they write such a vague phrase? And I say to them, that's what they meant to do. I used to spend a good bit of time in the Senate thinking up a vague phrase that would be acceptable to both the one side and the other side, and they could both vote for it and get the bill passed. That's the process. It's not a particularly subtle or point to grasp, but if you've been there, I think you just have a better appreciation of how important that is. Now, you may say, well, what about the legislative history? Doesn't that clear up the ambiguities? Well, then you get into the Scalia debate. Can we look at legislative history, or are we bound by the text? Do we want to touch on that, or are we?
Sure.
Well, to me, that's one of the silliest arguments that goes around. I mean, there's so many silly arguments in law, frankly, but that's one of the silliest. Somewhere, somebody said, we're all textualists now. I don't know who said that, but somebody important said that a few years ago. We're all textualists now. And if I had that person, I would die to ask, when weren't we? Of course you start with the text. Everybody knows that. The problem is that in the close cases, the text doesn't get you very far. That's why the parties are there. If it said 3 and the question was, did they mean 4? No, they meant 3. There wouldn't be a lawsuit. So they said something vague, unreasonable restraint of trade. Tell me what that means. Not self-defining terms. So, of course, you look at legislative history. I had a discussion with an interchange, fair to say, with Scalia once. We had a meeting of all the circuit judges, and he spoke. So I said, Justice Scalia, let me ask you about what I think is the easiest possible case in this area. Let's say there's a vague statute, the phrase, absolutely vague. And we have a legislative report from the relevant committee, and it says, when applied to a particular case, and it was our case, it just described our case exactly, and it says, if that case comes up, we mean it, we want the phrase to mean this. I said, why shouldn't we pay attention to what the relevant committee said? Well, Scalia thought for a second, and his first answer was, why should you? I said, because it's the report of the people most interested in that piece of legislation. He said, well, the whole Congress hasn't read it. I said, the whole Congress hasn't read the bill either. So, to me, it's just obvious. If the key committee has thought about the problem and given you some reasons how to interpret it, you follow it. And furthermore, if the committee has given a reason that several in Congress don't like, you can be sure the relevant interest groups will be in there the next day with a clarifying amendment to get it their way. So of course the legislative history is important, and of course we should look at it, and everybody understands that. And I even think Justice Scalia understood it too, because he would do it on occasion. So the idea that we have to be disciplined to follow text is just crazy. You by now, these are second, third year, first year, what do you got here, everybody?
I don't know.
Everybody,
What do we got
okay.
here?
Well, you've read a bunch of cases, and you've anything that involved a statute, it says we begin with the text, as if that's a profound observation. Of course you begin with the text, and if the text is clear, you're happy, because that makes the decision that much easier. But it rarely is. So then you have to figure out what to do. You can look at legislative history, that's one guide. You can look at the overall purpose of the statute. You can try to advance the purpose of the statute so that it fits with what the Congress is trying to do with the statute. You look at other things. You look at history. You look at precedent. You look at the structure of government. You draw your advice from wherever you can get it in order to make sense of a vague statute. And then, of course, whatever you do, the side that likes it says that was a brilliant interpretation, and the side that doesn't like it says you legislated from the bench. And you now have a political dialogue where people say, we want textualists, we don't want people who legislate from the bench. Well, again, it's just silly because all the judges, no matter who they're appointed by, start with text, and they do their level best to carry out the will of Congress. That's the system.
Let's go back to the confirmation process a little bit, since we just
Sure.
had a Supreme Court confirmation process, and that was one thing, and it does sort of highlight the differences, I think, within our system. Your district judge confirmation process took a toll on you.
The district court?
For the district court.
Not the, you mean the hearing
Not
or
the
the
hearing,
process?
The process.
Oh, of getting nominated.
The process of getting nominated was, the candidate is in quite a vulnerable position. And I don't know, we don't need to go into it too deeply, but there's a whole chapter in here where you thought your nomination was going down the drain.
I did. First, well, as I said, it was across party lines, so that made it very questionable. And it took a long time from the time that the senator first suggested my name until a nomination was made. That was, I think, 13 months. I was then a solo practitioner, and it's a little nerve-wracking now to know whether you're going to be a lawyer the next month or you're going to be a judge, and you've got clients, and you've got to deal with all that sort of thing. Then I had the issue, then the nomination was about to be made, and then there was an episode of opposition, and I didn't know where it was coming from. I had a call from a lawyer in Hartford who said, I got a funny call just now. He said, I'd been asked before about you, and I recommended you. He said, I got another call, and the call said, you sure you don't know anything adverse about Mr. Newman? And I thought, that's a funny question. He said, yeah, I thought it was a funny question, too. In any event, there was controversy. When you're considered for an important appointment, what you find out is who your friends are and who your enemies are. They come out of the woodwork, particularly the enemies. So it hung fire for a while. I'll leave the details for the book, but they're interesting.
The book is really good. It is interesting. But could we follow up on that a little bit? Because this confirmation process that we put aspirants to the bench through has some risks to it. Just like you say, if it's a controversial nomination in any way, or even if it isn't particularly controversial, the person going through it does have a sense that, well, I have friends and I have enemies, and then you put the robe on and you're to be a neutral arbiter. And how, can you just reflect on that?
Well, if you mean, does it leave scars? I don't think so. Of course, I went through relatively unscathed, certainly by the time I was nominated, and then the hearing for the Senate is district court hearing is a non-event. Your two senators come, they say you're a nice guy, and then the committee goes away. Court of Appeals is also relatively a non-event. Every once in a while, a Court of Appeals judge is controversial, but that's very rare. The only episode I had was sort of interesting. When I had my hearing for the Court of Appeals, anybody can come and oppose you. It's a democracy. We hear from citizens. So one person said he wanted to oppose me. He was the brother of a person, a pro se litigant I had ruled against probably 10 times as a district judge. And he wanted to come down and tell the Senate that my rulings were terrible. So it came time to hear him, and the chairman said, is there somebody here? Oh, yes. And he grabbed about 8 manila envelopes off of his table, and he brought them up and he laid them out very carefully, all my rulings. And he was 30 seconds into his ruling, into his peroration, and the quorum bells that are up at the top of the wall of the Senate, there are 3 lights and bells, they go off to tell them that there's a quorum call in the Senate and they have to go over and vote. So he's 30 seconds in and the lights flash and the bells go off and he looks up startled and he said, oh, is my time up? And the chairman said, no, no, no. Oh, yes, it is. Yes, it is. He almost missed it, but he caught on. That was the end of the hearing.
That's pretty funny. So 7 years on the district court, and then all of this time on the Court of Appeals, which has been the main body of your work. But it might be interesting to hear you reflect on sort of the differences in the life of a district judge sitting on a bench all alone, mm-hmm. and being a member of a multi-member court.
Well, there are lots of differences. The most profound is that on the district court, it's just you. So if you have the matter for decision, you make up your mind, and then you do something about it. On the Court of Appeals, you make up your mind, and then you decide what to do about it because you've got two other people to contend with. Usually, we're unanimous in our court. Our dissent rate is very low, as it is in most courts of appeals. That's because we have mandatory jurisdiction. So we got a lot of stuff that's very easy to decide, and we're unanimous. But on the controversial matters, you do have to deal with two colleagues, and you didn't have to do that on the district court. The main working difference is the pace of the work. On a district judge, you don't own your time. The lawyers own you. They monopolize your time. They come in at all hours of the day. You're running a trial, and then if it's Friday, 4:30, you're going to get a motion for a temporary restraining order. You know, because that's when they come in with it. And you got to stay there. Your wife may be home expecting you for dinner, but you have to deal with that 4:30 or 5 o'clock application. You're harassed. I was young. I went on at 39. That's probably too young. And I commuted from Hartford to New Haven. Every evening when I drove home, I was tired. As a 39-year-old young man, I was tired because it was a harassing day. I ran a trial, then I met with lawyers at a morning recess, then I met with lawyers at an afternoon recess, and then occasionally at 5 o'clock. And that's day after day after day, and it's tiring. Court of Appeals, you own your time. Once in a while you have an emergency, but it's very rare. So you hear a case, you'd like to decide it within a reasonable time for the benefit of the parties and the public, but there's no have to. Once in a while, to stay a merger. The merger's going to happen day after tomorrow, so you've got to deal with it. Death penalty, got to deal with it. An immediate deportation, got to deal with it. But those are the exceptions. Typically on the Court of Appeals, you are in charge of your own time, and that's a huge working condition difference from life on the district court. District court is a difficult position, tiring, demanding, but enjoyable.
Could you talk a little bit about the opinion writing process on the Second Circuit? Oh, and by the way, did you hear in these most recent hearings that the D.C. Circuit is the second most important court in the...
Heard it all the time.
Yeah.
And I wasn't sure, did that mean we're first or third? They always say that. They get some high visibility government cases because they're in D.C. It depends what you mean by important. If you think organized crime cases are important, we have many more than they have. We have many national security cases that originate in the Southern and Eastern District. I don't think there's much point in grading importance, really. We have our caseload. We have a huge amount of intellectual property cases. We in the Ninth Circuit have more intellectual property than anyone else. They have what they have. We have what we have. If you think it's important to write a 110-page opinion on a Federal Power Commission case, then I guess they're important.
Yeah, that's the way I always reasoned when I would look at, say, the Yale Law School. I would say, well, if that's what you think is important, then maybe they are number one. If you think actually studying law and becoming a really great lawyer is important, then Duke is number one.
I think, I suspect what really is behind that remark is the D.C. Circuit has sent more people to the Supreme Court, certainly lately, than any other court. So I think their importance derives from that phenomenon.
Well, that's true, and there are unique reasons for that. I mean, that has to do with what we were talking about before, which is the president doesn't have to deal with senators, and so can just put somebody there as a kind of waiting area, vestibule to the Supreme Court.
Yes, sure.
Yeah,
sure.
So, opinion writing.
Opinion writing. Well, on first is the assignment of the opinion. That varies around the country, actually, how it's done. Both state and federal courts, there are all kinds of different systems. Professor Levy is going to write about this next year. She doesn't know that yet, but she's going to. In our court, the opinion assignment is a non-event. We sit around, we come out right after the argument, we meet for a few minutes. We decide which cases will go by what we call a summary order, which in the old days, before Federal Appendix, we called an unpublished order because it didn't get into Federal Reporter. Now it's a published, unpublished opinion. ends up in federal appendix. It's 2 or 3 pages, just gets the answer. We do that because since we have mandatory jurisdiction and hundreds of cases that are just not worth clogging the federal reporter with. So we'll decide which cases can go by summary order. That's a quick decision, is made in just minutes. Then we have the, if I've heard 6 in the morning, there may be 1 or 2 that need a full opinion. Let me compare it to what we used to do, because I think this might be of interest. When I joined the court, after we heard oral argument, we would go back to we would not discuss the case in chambers, in conference. We would not discuss the merits. We would go back to our chambers, and each of the 3 of us would send out a memo of about 2 or 3 pages with our vote and our reasons for the vote. And we were actually sort of religious about it. If the other fellow's memo came in, or the other woman's memo came in, we would not read those until we had sent ours out, and we all were very faithful about that. Then when we met at the end of the week, we had these memos, we knew where we were. We only talked about the cases where there was a division. I thought that was the deliberative process at its best. 3 people were independently thinking about it, making up their at least tentative views, and then conferring. I thought that was the virtue of having 3 people. Volume overtook us. We don't do that anymore. We talk very briefly about the case. We vote. We assign the opinion. And the opinion writer pretty much has the franchise. What that means for the district courts and for lawyers and law students is don't overread our opinions. Now, this is a dilemma, because what's in your casebook? Opinions of courts of appeals and the Supreme Courts. So you are brought up, as I was brought up, to carefully parse every sentence. Well, that's good training. Careful reading is very good training for a lawyer. But my advice is, don't overread every sentence, because that sentence is not the work of all 3 judges or all 9 justices. It is the work of the opinion writer. And although it's there, I understand that, and it's what you got to work with, and when you're a lawyer, you're gonna, if that sentence helps you, you're gonna say, may it please the court, 3 years ago you said this, and that helps me, or it doesn't help the other, whatever. But pretty much we are not carefully analyzing the reasons in the opinion. And from what I know of the Supreme Court, both from years ago and now, that is still par for the course, and it's too bad. And there are paragraphs that end up in those opinions, particularly when they come down in May and June when they're in a hurry, that are just not helpful. They're not clear. They really upset what ought to be the clarity of the law. It's too bad. On the other hand, I don't want to denigrate it excessively. I think the work product of the federal judiciary is by and large quite good. Can hold its own with any country around the world, I think, and certainly in the state courts. So I think the opinions are constructed carefully, even though they're the product of 1 chambers. The degree of input from other chambers varies. I have some of my colleagues who love to exchange memos back and forth, even occasionally a phone call, though they don't do much orally. It's mostly in writing. And make some useful suggestions. And then if you're the opinion writer, you have a decision to make. Do you accept that suggestion and change your opinion? Do you say, thank you very much, but I really do not want to say that? What does that person then do? That person then has to decide either to dissent, write a concurrence, or gulp and sign up. Well, these are discrete decisions that you make in a group court. Maybe it happens in a group faculty, I don't know, but you're a group and you probably have to work things out every once in a while. So it's an interesting process. In our court, it is relatively rare that it's controversial. Supreme Court, it's obviously controversial because they only take the cases that divide them. What are they taking now? Writing full opinions in 80 cases a year out of thousands that they're asked to take. So they decide 5-4. Of course they decide 5-4. If they were deciding 9-0 most of the time, they were taking the wrong cases. So although there's a slight addition to that I might make later on if you want, but they're going to divide, and Then the question is, first, clarity. That's the first thing, I think. Make it clear. And then the issue is, how much ground do you cover? Do you write it broadly or narrowly? Well, that's a judgment you make. It depends what the subject matter is. If it's a matter that concerns the way district courts do business, I'd rather write it fairly broadly because it's helpful to them to know what the heck the Court of Appeals wants them to do. If it's in a field, antitrust law, intellectual property law, environmental law, I will probably not write broadly for the fundamental reason I don't know enough about it. And as I've said to now 95 law clerks over the years, you know the business we're in? It's damage control. We're trying to decide this case without messing up the adjacent areas that we don't know enough about. I think that's an important thing for any opinion writer to keep in mind.
So the Hippocratic oath for...
Do no damage. Do no judicial damage,
Yeah.
correct.
Yeah,
That's the judicial Hippocratic oath.
that makes sense. When you get a really hard case, you know, let's just say well, for this purpose, define a hard case as you could go either way and frequently do, and you're just not sure. Do you have an approach to those cases? Do you take a walk around the block? Do you knock it off? Do you have a colleague you might go to? Do you write two opinions? You know, how do you approach that kind of thing?
Funny you should mention that, because I once did write two opinions. I did actually write two opinions, one coming out one way or the other, sent them both out to the panel and said, I think this one is the right one, but I want to know what you think, and this is how the other one would look if we went the other way. I only did that once. I'll never do it again.
It's double the fun.
How do we decide? I think the honest answer is we don't know. If I have a close case, and I must say I quibble with the word difficult, it might be difficult. What I don't like much is the antonym when judges say in opinions, we have no difficulty deciding this question. And you've seen that in a lot of opinions. And I say, oh, big deal, you had no difficulty. Come on. The question, is it a close case?
Yeah.
There might be, to me, a difficult case would be one with a massive record, and you had to delve into 40,000 pages of testimony. That's difficult because of the task. The decision-making, I wouldn't call difficult. I would say it's a close question in that it could go either way. And there are some cases, not many, at my level, that could go either way. And I sometimes, after we've decided one of those, I'll sit down with the clerks and I'll say, what do you think really persuaded us to come out that way? And the answer is we don't know. We may articulate a reason. I doubt if we know it. But I don't think that's a judicial dilemma. I think that's a fact of decision-making in life. You all decided which law school to go to, which course to take, where to live, who to marry. You're going to decide which job to take. You will be able to articulate reasons for those decisions. Will they really, really be the reasons? Or was there something that you don't even know about in your background, your psyche, your upbringing, your parentage, that gave you a certain tilt towards a decision? I think all those things matter. It matters who we are. We're not computers. You don't feed the facts into a computer and press a M for majority opinion and out it comes. I'd love a D for dissent that I could just get that to come out of the computer, but it doesn't work that way.
Yeah.
So we're different. We're the product of who we are by everything, upbringing, religion, geography, everything, education, job experience. All that goes into who we are, and who we are does, on the close cases, affect how we come out. There's no question it does. But I don't know that we know precisely what causes us on a close case to go one way or the other.
So when you first became a district judge, you had what I'll call a challenging case, at any rate.
Certainly did.
You had one of the first abortion cases before
a pre-Roe.
A pre-Roe case.
Yes.
Could you talk about that a bit, because that I think that was quite an experience for a new judge.
Well, I'd been on the bench all of 2 months. I was 39 years old, and I was tapped to be a member of the 3 judge district courts. Those of you in civil procedure probably have heard of them as antique relics of an earlier day. But we had 3 judge district courts fairly frequently because the statute then said, whenever a litigant wants to enjoin the operation of a state statute, that requires a 3-judge district court. It would be 1 judge from the Court of Appeals and 2 judges from the district courts. We don't do that anymore except in some election law cases, but it's very rare. In any event, I was tapped to be on that 3-judge district court. We were looking at the 1860 Connecticut statute, and it was being challenged by a group of 200 pregnant women who said the statute was unconstitutional. One of my favorite moments on it was at one point they came to me for a temporary injunction, and I had to decide that alone. They said, "Judge, all we want is a ruling to preserve the status quo." I thought a minute and I said, well, I guess I have a lot of authority here, but I don't think with 200 pregnant women I can maintain the status quo. So we got past that. So the first issue was, what about the 1860 statute? Well, as I looked at it, it was passed in 1860 to protect the health of the mother, because abortions were very dangerous in those days, far more dangerous than childbirth. By 1972, childbirth was more dangerous than abortion. All the statistics showed that, the state agreed to that, the litigants agreed to that. So while the other 2 judges on the court were very sure what they wanted to do, one wanted to say it's clearly constitutional, one wanted to say it's clearly unconstitutional, I said, I don't think I really have to decide the ultimate question here, because this statute is just factually inapplicable. I said, I wrote a separate opinion. I said, I think there is something of a constitutional right, starting from Griswold, contraceptive case, and then a case called Eisenstadt against Baird, where Justice Brennan had talked about the right to bear or beget a child. That seemed to me a pretty good clue. At that point, I got to admit, I hung on his every word. And I said the 1860 statute is factually inapplicable. So if the Connecticut legislature wants to pass a statute to protect the life of the fetus, they'll have to tell me that's what they're trying to do. Within 5 weeks, they told me what they wanted to do. They sent up a bill, avowedly, explicitly said, we're protecting the life of the fetus. Now I had to decide the ultimate question. Well, I thought about it a while. I thought it was a close question. I thought it was a fair argument that the state can, if it wants to, ban abortion, despite the very strong arguments in favor of the woman's right. But I also thought there was a very strong argument to protect the woman's right. So I wrote an opinion that for the court, it was 2-1. Judge Lombard went with me, Judge Clary dissented, and said, at least before viability, the woman has a complete right to decide whether to carry the fetus to term. That I thought that after viability, the state's interest became quite significant, because now you had a fetus that is capable of surviving outside the womb. And I thought that meant the state's interest was very strong, whereas before viability, the state interest was certainly not as strong, and the woman's interest was very strong. So I ruled on that, and apparently they paid some attention to that in the Supreme Court. I didn't know that till years later when the papers of Powell and Marshall became available, and David Garrow's book, if you know, if you're interested. The best book on the whole history of abortion litigation is by David Garrow. Excellent report of the entire history of the litigation. And he prints the Powell memorandum that Powell sent to Blackmun and said, I think you should look at that opinion in the district court from Connecticut. It's interesting.
So you were influential. It's interesting to think of your tenure on the court, beginning with the abortion case, because the whole issue of abortion has been so powerful. Certainly, concerning the Supreme Court and Supreme Court appointments, it's I don't know what word you would use, but it's maybe it's haunted the court, or it's followed the court, or whatever. It's not an issue that is resolved. Maybe the court has resolved it, but is there a national consensus on this? I don't know. Maybe there is.
I doubt it. I think it's divided the country sharply.
And how do we, this is the kind of legal issue where you can see what your approach was, which was to go quite slowly, really. You were waiting for greater, before you leapt in, you wanted to know what Connecticut really wanted to do here.
Yeah.
Then they let you know.
Yes.
What was the response in Connecticut to your opinion?
Not much. Not much. Wasn't a burning issue. I don't even recall editorials. I don't think so. I think it was pretty much a non-event within the state. But the issue hadn't become a great national issue until the Supreme Court decided Roe.
Right.
But this is just a Connecticut District Court. What do they? I mean, you know, just
What did you know?
The lowest level.
Yeah.
No, today a three-judge court like that would have attracted attention, but it really didn't then. It really didn't.
When you got the case, you didn't look at this and say, "Oh my goodness, you know, that's it for me." You know, I think a judge now, if you got, for example, you know what you know where I'm going with this.
I guess I do.
Well, it's
No, I didn't think about that at all.
Yeah.
Did I think how's this going to affect my career? Not at all.
Yeah.
Not at all. I certainly knew it was an interesting case. I thought there was a high probability it's going to the Supreme Court. And in those days, procedurally, from a three-judge district court, you go right to the Supreme Court. You don't stop at the Court of Appeals. And I thought, and although they can make it go away by saying we dismiss for want of a substantial federal question, pretty tough sell to say that in an abortion case. So I thought, sure, I was naive, but I wasn't so naive that I didn't realize this is going to the Supreme Court. And there were a couple of other cases around the country. So it was going there. I thought I was, among other things, predicting what they were likely to do. I did think about that. And like quoting from Eisenstadt against Baird, I thought, oh, that's what they seem to be hinting at. Did I think how it would affect me personally? I can honestly say no. At least I think that. Now, again, am I right in thinking that? I don't know. Yeah. But I don't think so. I certainly didn't consciously say to myself and my law clerks, gee, gosh, if I go this way, you know, am I ever going to get another judge? No, none of that. Honestly, none of that.
Yeah. Let's, because we're running out of time, we're going to have you here for the week, which is wonderful. Maybe students can come drop by and talk to you
Anytime.
about some of these things. But if I could give you 3 wishes, let's say, for our legal or judicial system, the three reforms you could implement, what might they be?
Well, I guess there's a division between those that are even remotely feasible and those that I have to be czar to bring about. So passing that distinction, I guess the first thing I would do is abolish the civil jury system. One of my main concerns about the whole judicial process in this country is it's way too costly and way too slow. And one of the contributors to that is the civil jury process. I think the criminal jury is vital. I think the idea that the government can't take a person and put him in prison unless 12 people are in between the decision to prosecute and the decision to lock up. I think that is fabulous. But civil, I disagree. We're moving money around. And we're the only country in the world that has a civil jury for the totality of money cases. The British have it for what, defamation or something a little like that. And a couple of countries have, France has a quasi-jury system of some judges and some jurors. But for the most of the world, if they're moving money around between those injured in an accident, product liability, car cases, whatever, they have judges, maybe a panel of 3 judges. They do it quicker. There is far less cost to the litigants. There's far less delay to the process. We have these delays in some courts, 3 years, 4 years before you get a trial. I don't think that's right. And I don't think you need the civil jury to do it. And I think the system would be fairer, more efficient if we abolished it completely and just kept the jury for civil. So that's the first thing I do.
Okay.
You want others?
I'm I'm stunned by that, and actually,
well,
and we see it differently, which is sort of interesting. You were appointed by a Democratic senator. It was your person, and then President Carter, and I'm a Bush appointee. But I think the civil jury is very important.
For whom?
Well, I
For
think
whom?
I will say for the jurors.
Oh, it's great for them.
Well, but that's my point. It's part of having a democratic element to our legal system, and
Yeah.
in that sense, it's important for the courts too, because as you remember, the jurors come into court and they have this experience, and they leave with the sense that this is something very important to our country.
Well, I agree with that. You don't think criminal is enough for them?
I don't think it's enough because we're not seeing many criminal trials anymore, for one thing. That's the
true.
sentencing guidelines, which is you're going to be talking about later this
Yes.
week. So I don't know. I'd like to think a little bit more. There are also other parts of what we do in the civil side, in the civil rights area, for example, Title VII, which are very much invested with kind of community values, I would say. And I think that's hard for a judge to know. Like,
Doesn't it bother you that the rest of the world thinks we're nuts to do it?
no.
Well, I mean, are we so? I mean, I know we're exceptional. We're exceptional.
Yeah.
But isn't it odd that out of the whole world, we have this slow, cumbersome, expensive system, and the rest of them move money around without doing that?
Yeah, I mean, I take your point. We do need to be efficient. That access to justice it's meaningless if the justice is so inefficient and so expensive that by the time you get access to it, you can't afford it.
All
Okay,
right.
but so that
Another
was
one?
number one.
Number two, well, if I could do it, I'd eliminate it, but since I can't even remotely suggest that, I would sharply limit diversity jurisdiction.
Yeah.
Sharply limit it in ways, I won't go into the details, I'll do it at some point later if we want, but sharply limit. To me, it is crazy that we don't insist that state courts decide state law. I mean, we do it, we say so. Oh, Erie, yes. Well, of course, we go with state law. Well, who better decides state law than a state court? Why on earth would you want to funnel every little traffic accident into a federal court? That's crazy. Why do they do it? Because the lawyers like it. They want to be in federal court. By and large, they think they get a slightly higher quality of judge. I don't want to denigrate the state systems, but if you ask the lawyers, they'll say, if we have a choice, we'd rather go to federal court. We think on average we get a better judge, and the procedures are generally simpler. Well, I don't think the court system was designed to make the lawyers happy. I really don't. I know that's a shocking thought, but I really don't think so. So I would substantially leave almost all diversity cases to the state courts. And if I got time for one more?
You do. I just want to register a partial dissent, but go ahead.
I never mind a partial dissent.
Number three.
The third one would be, I would change our rules on standing so that any citizen could come to court to bring a suit to say that the action of the government unit or a government official was illegal, was unconstitutional, or in excess of a statute. Now, as you know, if you've gotten so far as to worry about standing in civil procedure, we have to have an immediate injury to make the issue concrete. What a thought. You mean to say that if Joe Citizen walked into court tomorrow and said the action of the Secretary of State, Defense, wherever, is illegal, there wouldn't be 10 public interest firms in there helping Joe Citizen bring that case? Of course there would be. So you don't need concrete injury to have adequate representation. Would you have a lot of cases? You'd probably have a lot of cases. But federal courts can handle that. They would consolidate them, or they would take one as the lead case and stay all the others. Israel, you might be interested to know, lets any citizen walk into court and challenge the government for acting illegally. And their system runs far more efficiently than ours. So I would have I would allow all people to hold government and government officers to account for unconstitutional action, allegedly unconstitutional action, or action in violation of a federal statute. I wouldn't do it to the full range of civil litigation. I wouldn't have every little busybody coming in and saying, oh, I understand Joe did an unfair thing to Mary, or Mary to Joe. No, we don't need to take all, I would keep standing for all the general run of litigation. I'm talking about governmental action, because I think one of the most important things courts do is hold government to account. That's really one of their principal purposes for existing. I'm always, I hope I'm careful about it, but I'm always intrigued when I hear a case, either in the district court or now on appeal, and there's the U.S. attorney standing in front of me, and what is he really saying, he or she? Your Honor, the government asserts the right to do X. He's asking my permission. He's asking me to decide if he gets to do that. That's an astonishing thing to happen, and a lot of judges, they take it for granted because it's what we do. We get to rule for the government, against the government. But when you think about it, it's an amazing thing. Because when we say you can't do that, what can we do? We have no army, a couple of marshals. But the system depends on the judges being able to rule when the government has exceeded its power. That is such an extraordinary thing. We ought never to lose sight of how extraordinary it is.
That's very eloquently put. Again, I'm in dissent, but I take your point seriously. I think if you could cabin it a little bit, I'd be concerned that the brother of the fellow that you had ruled against would be making regular appearances around the country in the district courts of our land, because people are always upset in one way or another. And I view standing as one of the ways in which we meter the activity of the courts. You know, it's a rough measure of how important something is, and but it is rough. And so I take your point. How about our civil jury out here? Does anybody
or anything else?
Does
anything else?
No, I meant there are jurors.
Oh, I thought you wanted a question. Oh,
no, I do. I would like to hear
whatever.
I would like to hear a question from the audience. Yes, sir.
In your first wish, you talked about providing efficient justice to litigants, but then in your third wish, it seems like it would create a lot more court cases. Does the rise of nationwide injunctions at all give you any pause for efficient government administration in a lot of other cases that could be impacted if we went to your third wish?
Well, whether there should be nationwide injunctions, I think, is not a necessary corollary of having a relaxed standing rule. You could have a lawsuit where an individual who thinks the government acted improperly enjoining just that precise action. Now, if the action was by a cabinet officer, it might have nationwide significance. If he was going against the local sheriff, the local police chief, it wouldn't. I think whether there should be nationwide injunctions is a very serious question. It's being debated in Congress now. There are bills to limit it. That's a fair question. But I think in my mind, I would separate that from the issue of holding government and government officials accountable for what they do. But if your premise is I'm being a little inconsistent in wanting to save money and at the same time spend it, yes. Yes, I probably am. I think I can give you a lot of ways to cut down on the time and cost of litigation, even if I foment just a little litigation by more relaxed standing requirements.
So we have a hard stop at 1:30, and before then, here's what I'd like you to do. I'd like you to give us the name of a judge you most admire, if you can, that you've worked with, you've known, or it could be a historical.
That's easy. Well, I give you one I worked with and one historical, okay? One of each?
And then advice to
Easy.
a law student. What advice would you have for them?
Well, the judge's easy. Judges I've worked with, it's just so, in a class by himself, Henry Friendly, without a doubt. I mean, it's a phenomenal judge. I don't know how many of his opinions you've read. They are remarkable, just absolutely remarkable. They're careful, they're thoughtful, they're imaginative. They contribute to the law. They not only decide the case, but they make that area of the law more coherent, just in a class by himself. If I want historical, Robert Jackson, best writer ever to sit on the Supreme Court. I agree with almost everything he decided, not quite everything, but almost. And I just love reading his opinions because they're well written. And they're clear, well written, forceful. All he wrote was forceful. If you want to read something well written, read his opening statement of the Nuremberg Tribunal. If you want to read a great piece of rhetoric, wow, could he write? Advice to students. Well, that's sort of your business, isn't it? I mean,
It used to be.
advice to students. Well, you started right by picking such a great law school. That was the first good decision. I guess you're going to spend your time reading appellate opinions, and I have said don't take them too seriously. You're going to learn to extract rules of law from them, and that's a useful training. But don't dwell on every single phrase, and get used to the give and take of legal argumentation. It's different than sort of public policy debates. It's a little more technical. You're in a technical field. And there are rules, there are principles, sometimes very narrow rules, and you got to deal with those. That's okay. I assume the architects have all kinds of technical stuff they do, and the engineers, the doctors certainly got to do it. So you got to learn your technical stuff as well. Don't ignore it, but think beyond it. Get your rules under your belt, your technical. I don't mean just procedural rules. I mean rules of how you deal with cases, how you reason by analogy. Get to understand all those, and then think beyond that. Think broadly as you can. Read a lot. Read some history. You've read history before you got here. Keep reading it. And as you write as carefully as you can. Read the sentence and say, is everybody going to understand what that sentence meant? You know what it meant because you wrote it, but read it and say, will somebody else understand it? Because the business you're in is writing. And so clarity of writing is one of the most important skills you can develop while you're here.
Well, that is just marvelous. You know, our hero, Justice Jackson, once spoke of a munificent bequest in a pauper's will to indicate something that seemed to be promising, but ultimately ended up being nothing. And you have very much fulfilled our hopes for today.
Good.
And I think everybody can join me in thanking you for doing this.